Good morning, everybody. Thank you so much for having me here. As Kevin mentioned in his very kind opening remarks, I currently practice labor and employment in Regina with Miller Thompson, but what seems sometimes like a lifetime ago, I spent about 3.5 years working for the Workers' Safety and Compensation Commission for the Northwest Territories in Nunavut up in Yellowknife. And so I'm always pleased to be able to partner with the WCB and WorkSafe Saskatchewan because it feels a little bit like I've come home. So thank you very much for having me here today. It's a pleasure to be here. I am going to speak about cannabis in the workplace, marijuana in the workplace today. I know that we're just a little bit behind schedule, and so I'm going to make my best efforts to make up some time. What that means sort of practically is I'm going to provide some high-level remarks and overview. I'll mention this a few times through my presentation, but so often in this area of the law, the process by which the parties and employers and workers reach an accommodation plan or deal with cannabis in the workplace is as important as the actual outcome. So what I'm really going to focus my remarks on today is that process. And by going through some sort of high-level objectives about the rights and responsibilities of both employers and employees. Oftentimes I present sort of from an employer-centric approach, but I've really tried to include in my comments today things that employees or workers really need to be aware of too. And what it boils down to, and I'll come back to this a couple of times, is the overall importance of fostering a culture of safety in the workplace, and that's the responsibility of everybody in the workplace. From a high-level perspective, of course, cannabis use or marijuana use can cause a number of short-term effects, including an impairment of one's ability to drive safely or operate equipment. It can make it harder to learn and remember things, affect mood and feelings. And long-term effects of cannabis can include a lot of physical damage akin to smoking, but of course, this is now legal. So from a recreational use perspective, there can still be, of course, a regular and immediate impact on those who consume cannabis. From a therapeutic use, we know that cannabis can be prescribed through an authorization to treat a number of different conditions and disabilities. Legalization of cannabis, what essentially occurred in October of 2018, has had no impact at this point in time, at least, on the therapeutic use of medicinal marijuana. The process that's in place for an individual who has an underlying health condition or disability to receive an authorization from a physician is outside of the retail sector. That being said, the legalization of cannabis is, I think is a good opportunity to have a conversation about both the recreational side as well as the therapeutic or medicinal use, and I'll touch upon both through my presentation today. We know that cannabis impairment is going to depend on a number of factors, and I've listed a few of them here today. Similar to alcohol content that can differ from beer to wine to heavy liquor, the strain potency is going to be a considerable factor in terms of the type of impairment and the depth or level of impairment that results, as well as the individual user's physiology, the frequency of use, and the method of consumption. So why are we focusing on cannabis? Why are we having the conversation here today? There's two primary reasons or areas of focus or rationale to talk about it. The first is from an occupational health and safety perspective, and the second is from, broadly speaking, the human rights perspective, and I'll go through the accommodation in the workplace considerations as well. In terms of the second one, the accommodation in the workplace, there's obligations that are placed on employers both in working with employees who have that authorization for medicinal use, as well as working with employees who have developed a dependency on cannabis use. Dependency on drugs, whether they're legal or illegal, is a recognized disability in Saskatchewan and across Canada. And so they're sort of two sides of the same coin, and we'll have a chance to talk about both of them. It's also important to know, and we'll go through the role that employees play, both in the occupational health and safety perspective and in the accommodation. Courts and tribunal have called the accommodation process, the human rights considerations, a multi-party inquiry. Although there's a number of responsibilities and obligations placed on employers, it's important to recognize at the outset that workers and unions, where it's a unionized work environment, have significant and detailed involvement as well. So we'll start with the health and safety perspective. The duties that are imposed on an employer, regardless of the type or manner of worksite, include the obligation to ensure that the employer's workers are trained in all matters that are necessary to protect their health, safety, and welfare. What I've done here is I've just included an excerpt from the Saskatchewan Employment Act, which is the sort of overarching or big picture obligation that's placed on employers to ensure, insofar as reasonably practicable, the health, safety, and welfare of all of the employer's workers. This type of obligation is correspondingly placed on supervisors, on contractors, on employees as well. And what I'm going to do is just go through the employer's obligations first and then come back to the employees. So I want to talk for just a minute about the concept of due diligence. This may be something that's familiar to many or most of you, but from a legal perspective, from a legal concept, due diligence is the level of judgment, care, or prudence that a person would reasonably expect to do under a particular circumstance. So reasonably practicable is actually defined in the occupational health and safety regulations. It's practicable unless the person on whom a duty is placed can show that there is a gross disproportion between the benefit of the duty and the cost and time, trouble, and money of the measures to secure it. What constitutes due diligence for any particular employer and any particular worksite is going to differ. It is a case-by-case determination. And what's appropriate for an office setting is going to be perhaps not necessarily appropriate for a construction site or a retail or a manufacturing employer. Due diligence, essentially, is what an employer must show to demonstrate that you've met your obligations as an employer under Section 3 Sub 8 of the Saskatchewan Employment Act, the one that we had just looked at, to show that you are ensuring the health and safety of your employees. From my perspective, and this is what I counsel my clients, due diligence starts with your occupational health and safety policies. I'm going to spend some time today talking about the importance of policies, again, sort of from a big picture perspective, but it's going to start with your policies, practices, and procedures. Due diligence is a legal defense that is going to ask 3 questions. The first is foreseeability. Could a reasonable person foresee that something could go wrong? The second is preventability. Is there an opportunity to prevent an injury or an incident? And the third question is control. Who has the ability or responsibility to prevent an injury or incident from occurring? Most often, it's going to be the employer who has that level of control. Control over the work site, control over the way in which the work is done, control over the workers. But I think that it is important for employees, for workers to acknowledge and recognize the level of control, both individually and collectively, that they also exercise over a particular job or a particular work site. In an office setting, due diligence may include checking for trip hazards, such as boxes piled up in a doorway, and implementing a procedure for where those boxes may be stored. In a retail or restaurant setting, due diligence may look a little different, and it may include having a policy in place that mandates a minimum of 2 employees will work at night. For a construction company, due diligence may include daily tailgate meetings to review safety considerations for the particular job that will be performed that day. In every situation, due diligence is going to include the provision of accurate, up-to-date information to employees. When we're talking about occupational health and safety policies and procedures, what I've done here is I've just listed a number of bullet points that comes from a resource published by the provincial government. I always have a tough time with all of these ones that you have to click each time. Sorry. Really, this is what should be the core of any occupational health and safety program. You want to have it in writing, you want to have it workplace specific with a commitment from management in a way that's communicated to workers so that you have worker buy-in. The regulations identify that an occupational health and safety program have to include a statement of the employer's policy. the identification of existing and potential risks and measures that will be taken to reduce, eliminate, or control that risk, a schedule for the regular inspection of the place of employment and the work processes and procedures, as well as a plan for training workers and supervisors. Due diligence is the defense. This is what you're looking at after an incident has occurred, after there has been some type of serious incident, perhaps resulting in injury to worker. Due diligence is what must be proven in order to successfully defend against charges under occupational health and safety legislation. Of course, the goal is to avoid that type of incident so that you aren't dealing with occupational health and safety charges. But in the event that any employer is, you need to be able to prove due diligence. And of course, there's penalties for failure. Saskatchewan now has the highest penalty for incidents causing the serious injury or death of a worker in Canada. The amounts are comparable to penalties of the same offenses in BC, Alberta, and Manitoba. And what we're seeing, what I'm seeing when I sort of look across jurisdictions, is this move towards higher upper limits of fines, penalties, where charges result. And I think, you know, it's probably no news to anybody who's sitting here that this is from a corresponding increase in attention and detail put on occupational health and safety in the workplace. It's the other side of the coin, having you know, more education, higher standards, greater expectations that are communicated through legislation, knowing, or that employers know what the outcome is if they are not taking this seriously. So let's talk about employee obligations for a minute. Employees certainly have a duty to perform their jobs safely, which includes the need to understand their job and the impact of using substances could have on safety. Employees also have an obligation to follow prescribed health and safety legislation. And what I've included here is the excerpt from the Saskatchewan Employment Act that places a broad and general obligation on employees, on workers, to take reasonable care to protect his or her health and safety, that's the individual's workers' health and safety, and the health and safety of other workers who may be affected by the individual workers' acts or omissions. There's no explicit prohibition in our legislation on impairment at work, only the general requirement to take reasonable care. The question then comes down to how is that interpreted? Well, if we talk about what hasn't changed in terms of legalization of cannabis that occurred in October of 2018, what hasn't changed is that workers are not permitted to be impaired at work or pose a safety risk to their coworkers or the public, regardless of whether they have a prescription, whether they have that authorization or not, and regardless of whether cannabis is legal. So taking a step back then, if workers are required to also practice reasonable care, and if the legalization of cannabis and the opportunity to have medical authorization is there, what does that mean then for workers? Well, employers need to ensure that their employees know what's expected of them. As an employee, workers have to know and understand and participate in maintaining a safety culture, which comes, at least in part, from following the workplace standards that are in place. Workplace standards are going to be implemented, communicated through, at least in part, workplace policies. Employers need to clearly establish expectations for their workers and to identify those outcomes for failing to meet those expectations. This includes knowing that impairment at work is not acceptable, that impairment at work is deemed and considered to be a safety risk. The best way to do that, I think, is through workplace policies. Policies that apply equally to all workers, regardless of the position that you hold in a particular company. The obvious or outlier situations of impairment in the workplace are the easier ones to deal with. When we were really dealing with or planning for legalization to happen last summer and fall, you get the questions of, well, what am I going to do? And every worker and every employer is thinking about that situation where somebody rocks up to work in the morning and opens their car door and out comes a great big puff of smoke. And the person is so obviously impaired that there's no issue of question or judgment. This person cannot come to work, they're obviously impaired. Those are going to be the easy situations to deal with. It's the outlier situations where it's not clear to an employer, it's not clear to a supervisor, it's not clear to a coworker on a particular job if the person that they're working with is impaired. And what do you do in those types of situations? Again, what I say is that it's the process that counts just as much as the actual outcome. So how are you dealing with a worker who you suspect is impaired? How would a worker confront a coworker that you think may be impaired, or who has said to you over morning coffee break that they've consumed some type of cannabis edible, and you're now not sure whether or not they may be impaired and whether they're going to be a safety risk? Broadly speaking, an employer is not able to dictate what workers do on their time off. Cannabis is legal, so any worker who wants to consume cannabis on a Saturday night when they're home watching a ball game is perfectly able to do that. The issue then is, but are they expected to work on the Saturday night midnight shift? Or if they come in on Monday morning, is the effects of the impairment going to be worn off? That's the primary consideration. Turning to the second sort of broad topic of human rights, the Saskatchewan Human Rights Code places a duty on employers to accommodate workers who have disabilities. That includes both accommodating the use of medicinal marijuana, as well as accommodating the disability of substance dependency. Now, in terms of employers who are thinking about preparing policies, updating policies, starting from scratch, we often get the question of, should we just put everything in one policy, or should you have separate ones? I think a little bit it depends on the type of work that you're doing, the size of the workforce, the size of the company. But in terms of best practices, and that's really what I'm trying to highlight here today, I generally recommend, in terms of best practices, having one policy that outlines from an occupational health and safety perspective the expectations on workers with respect to impairment and attending at work, fit for work and fit for duty, and a second one that touches on what we broadly call the human rights considerations, the accommodation questions. And the reason for that is because you can have issues arise in a workplace touching on human rights, touching on accommodation, that goes far beyond issues of impairment. And of course, everybody can think of, the situation of hurting your arm and requiring light work for a period of time, or having some type of illness that lasts for a while and having to be off work, requiring accommodation for health or disability issues that arise that are separate and apart from cannabis and impairment issues. So we know that cannabis causes impairment. What does a worker do, what does an employer do when a worker provides a doctor's note to say that they have a prescription for medicinal marijuana? Similarly, another question to pose is, like alcohol, we know that people can develop a dependency on marijuana use, on cannabis, and it's known that similar to other drugs and intoxicants, such dependency will be treated as a disability. So as an employer, how are you approaching a worker that you suspect or know has a dependency on cannabis or any other type of drug? Section 16 of the code states that no employer shall refuse to employ or continue to employ or otherwise discriminate against any person or class of persons with respect to employment on any term of employment on the basis of a prohibited ground. Disability is a prohibited ground. So that's the obligation that's placed specifically on an employer, not to discriminate in terms of employment, and that's a very broad requirement. Under human rights, the Human Rights Commission, the courts, where a complaint of discrimination in employment is upheld, there's a very broad range of remedial awards that may be made, including essentially a make-whole provision that employees who have been discriminated against can be reinstated to employment if they had been terminated, back pay for wages and lost benefits, as well as up to $20,000 for injury to dignity and hurt feelings. So for employers, there can be a very significant cost where there is, in fact, a breach of the Human Rights Code. With respect to medicinal marijuana, the question is, why are workplace accommodation policies or procedures important? The duty to accommodate an individual who has an underlying disability or health condition that results in an authorization to use medicinal marijuana, that duty to accommodate is going to extend to the point of undue hardship. This is a legal term, it's defined within the code, and it essentially means, if you boil it down, intolerable financial cost or disruption to business. It is a very high standard to meet. So what I've done is I've identified, what are the issues? And again, the purpose of today's discussion and presentation is to provide sort of a high-level overview of what you should be thinking about and what you should be considering. The answers to these questions are going to be different for every workplace and for every employer. Again, the reason for that is because it is about the process. The process is just as important as the outcome here. But you need to think about how different positions are impacted by the use of prescribed marijuana and whether that prescription, that authorization is for short-term use or long-term use. People often think about, immediately go to the situation of safety sensitive, and you have to, especially in a workplace that does include safety sensitive positions. But I encourage employers not to stop there. If you have an employee, if you have a worker who has an authorization, you really need to do the same type of risk analysis and hazard analysis as you would for a safety-sensitive position. What does it mean if that person is forward-facing to clients or customers? How might impairment resulting from medicinal marijuana impact that? You need to go through that process. You need to ask those questions. And certainly, of course, if it is a safety-sensitive position, if we're talking about, a construction or manufacturing, the consideration in the process has to be quite detailed. Similarly, if you have an employee who has developed a dependency on cannabis, there are a second set or a separate set of questions that you need to be asking yourself, although they aren't necessarily all that different. You need to be aware of the obligations as an employer where an employee discloses that they have developed a dependency. How would you, if you ask yourself, how would your human resource personnel, how would you deal with that type of disclosure? Similarly, what steps should you take as an employer if you suspect that somebody has a dependency? Now let's flip it and talk about it from the worker's perspective. If you're a worker and you suspect that a colleague, a coworker, has developed a dependency to cannabis because of the way that they talk about their use, because of what you see in terms of their attendance, how they present at work, if you have a concern, how are you approaching this? I think, perhaps because legalization of cannabis is still so recent, that it is treated differently than other types of dependencies and other types of issues. I think that in most workplaces in the province, most workers, if they see a coworker struggling, and it doesn't matter if they're struggling because they have an ill parent or they have a child who's having issues, or because they have their brother's been diagnosed with cancer or they've been diagnosed with cancer, people generally respond empathetically. They say, "How are you? You seem like you're not doing all that well. Can I help with anything? Have you talked to anybody? Do you need to talk to anybody?" Cannabis dependency essentially has to be treated the same way. And that goes for somebody who has an authorization to use medicinal marijuana who similarly has an underlying health condition. Still, and I appreciate, and I know that everybody here does as well, there are competing tensions between asking these questions in a respectful way, which still acknowledges that most of the time there are privacy implications for the individual worker involved, with the overall culture and requirement for safety. And how are those two tensions, how does that play out in a practical way on the job site? Again, the tough thing about accommodation is that there's no one-size-fits-all approach. So anytime employers are looking to draft an accommodation policy, I say you have to stay both general and specific. You have to be able to have something that's specific enough so people know how to use the tool, know how to access the resources that they need, but general enough that it can apply to just about any situation where accommodation is going to arise. So what I've done is really high level. I've just sketched out, broadly speaking, the steps for accommodation. You want to make sure that it's written. You want to have an understanding of the roles and responsibilities for the position that the worker is in. You have to identify accommodation components that are based on the medical information. We're going to talk a little bit about the privacy implications in just a minute. You want to make sure you have a go-to person that the employee can come to with questions about the accommodation process, where things change, where the medical information gets updated, and you want to know what changes will be deemed significant and when there's a need for updated medical information. Again, from a best practices perspective, you need to be focused on the process. Anytime that we are talking about accommodation, while it is the employer that's going to be sort of guiding the ship, leading the way, it's integral to have full buy-in and participation from the worker. It just doesn't, it's not going to be a success if this is not approached as a true multi-party inquiry. So what does that mean from the worker's perspective then? The worker has to acknowledge that they may be sharing information that they wouldn't otherwise share with their work colleagues. The worker also needs to know then that that information is going to be treated in a respectful and confidential way. That's an aspect of the process and the policy that has to be conveyed to the worker and has to be confirmed. Where an accommodation plan is put in place, and this is again going to be regardless of whether it's because we're talking about a medicinal authorization or we're talking about a cannabis dependency, you want to have an actual written plan that results from these conversations. This should be signed by all of the parties. And you know, there is a recognition that you may get through the process. You may have these conversations. You may be doing the hazard assessment and the consideration of the particular position, and know that it's not possible to adapt that particular worker's position so that they can be accommodated in their own position. You can't, as an employer, you cannot leap to that conclusion. You can't say, you know, the end will not justify the means. You have to be able to, you know, I call it showing your math, really. You have to be able to know. And what I would say to employers when I work with them is, if you can go through that process in a way that engages the worker and the worker feels valued and they feel like they are a part of that process, you're going to end up, at least in some cases, with worker buy-in and understanding about why the proposed plan does or doesn't work. And this is integral. And this is why the workers need to be just as involved in the process as the employer. So this idea of reaching undue hardship, of at some times appreciating that a particular position cannot be adapted, that the use of medicinal marijuana is too much of a risk for that particular company, for the jobs that are available, to say we've reached the point of undue hardship, we can't do this. What does that mean and what does that look like? Well, where an employer gets to the point to say, we've reached undue hardship, we can't go any further in this process, in assessing whether or not the employer was correct in reaching that conclusion, the courts are going to look at a long list of factors. I've listed a few of them here. One is the cost to accommodate, to have the person, you know, working part-time hours, working a different position, modifying some aspect of how they do their work, the resulting change to the workplace, and any risk to health and safety. And what I've seen from sort of taking a step back and looking at the cases over the past couple of years is there has been sort of this pendulum shift. And I think that a couple of years ago, if we sort of took a bigger or broader perspective, I think that a couple of years ago, the concept of risk to health and safety was placed slightly lower on the weighing of what is taken into account when reaching undue hardship. And I think that there has just been a swing back a little bit towards focusing on that a little bit more. That's not to say in any way that I think that courts or tribunals, human rights tribunals, have disregarded safety, health and safety, but I think that they've just required employers to come up with more creative solutions and opportunities. So I'm sort of curious, and I'm watching, especially over the course of the next year, now that we're starting to get into some decisions post legalization of cannabis, where that pendulum is going to sort of come to rest. Another consideration that I don't have listed here in terms of reaching undue hardship is going to be the size of the employer. Separate from the issue of impairment and cannabis in the workplace, I was speaking with somebody who worked within the provincial government in the area of human resources and accommodation, and they said, the provincial government, we can never reach undue hardship because there's always going to be another position. There's always something else. So, an employer the size of the provincial government is going to be treated differently than a corner store who has 2 employees, right, in terms of what opportunities are there to accommodate somebody. So coming back to this tension between worker privacy and workers legitimately wanting to ensure that only the bare minimum of their highly confidential medical information needs to be disclosed, with this concept of assessing whether somebody, particularly in the safety-sensitive position, can perform their role while they are consuming medicinal marijuana. So, we often get the question, how much information is an employer entitled to receive from a medical doctor? The sort of snapshot, or if you boil it down, is prognosis and not diagnosis. So prognosis is going to talk about, this particular worker, we expect that they'll have to require this particular authorization for at least 6 months. We should be taking it at this time in this dose, and we recommend that they not perform any safety-sensitive positions for that time. Or they may say, we recommend that they don't perform safety-sensitive positions for the first 2 hours of the workday. So you get the prognosis in terms of, well, we're going to reassess in approximately 6 months, but you don't have any right as an employer to know what the underlying medical condition is. It's because this person has, cystic fibrosis, or because they're dealing with cancer treatments, or whatever it is. The worker is able to disclose that, but it gets really sticky where the employer starts asking the worker questions, well, why is this? What's going on? Again, I think that oftentimes, if you look at it from a really practical perspective, you're talking about a workforce where people, they know each other, they work together all of the time, right? If you have a coworker and they come to you with a medicinal marijuana authorization, human resources may genuinely say, because they have some compassion and empathy, oh, I'm so sorry to hear this, what's going on? Is everything okay? And so oftentimes when I get calls, when I get files, I find it's at this stage where there's a breakdown in communication between the worker and the employer, because the worker is feeling oftentimes, overwhelmed with perhaps a new diagnosis and a new normal, and worrying about this and feeling like, oh my gosh, now I have to answer all these questions at work, and I don't know what I'm supposed to say, and I don't know if they're allowed to ask me those questions. Again, if we come back and sort of take a step back and think about the importance of policies, your human resource person, who perhaps doesn't have a ton of experience dealing with medicinal marijuana, has a roadmap and has a guide. And equally, the worker can know, what's my role in this process? What am I supposed to be telling? What do I have to give? How is this information going to be treated? Oh, look, the policy confirms it's going to be on a need-to-know basis, stay with human resources, and will be treated confidentially. If those sort of, ground rules are set up from the very beginning, I think it helps both parties. I would just make one more point here, and I think too that in terms of workers who are at this point and who are, wondering, how do I walk into the office? How do I disclose this? What type of questions are they going to ask me? To think about it from the safety culture perspective. Think about it as the individual employee. So my doctor has said I should take this medicinal marijuana. largely speaking, because of the time at which I take it at night, it shouldn't cause impairment, I should be fine, but they've recommended that I don't operate any motor vehicles in the mornings. That should be between 8 when I wake up and noon. Well, if you think about it, if workers think about it from the perspective of a safety culture, would you want to know if your coworker had that same limitation placed on them? Would you want to know that your coworker was not supposed to be driving that truck around the yard? And if you think about it that way, I think that we can really come down, as equally interested parties to figuring out solutions to these types of issues, which do arise and will continue to arise. I'm just going to kind of skip through testing for impairment a little bit. I want to try and leave some time for questions. But I'll say this broadly speaking, testing for cannabis impairment is just simply not there. It's not at the same point as testing for alcohol. I know that there are companies out there who are selling a product that talk about ways that you can test for impairment. I have no knowledge as to whether or not they work. I know that when I look at the arbitration cases, arbitrators are looking for direction. They're looking for some experts to help them in trying to determine what impairment looks like, but I don't think that we're there yet. We may get there. So as a result, if we don't have a good way of really testing for impairment, then it comes down to what are you doing? Lots of workers are, reasonably worried about the idea of drug tests in the workplace. Lots of employers ask whether they can do it, when they can do it. Generally speaking, employers can do drug testing in the workplace, but only where there's reasonable cause to believe that the employee was impaired while on duty. And this comes back to the question then, how do you know that they were impaired on duty? There's a lot of reliance on objective factors at this point in time, unless you're doing fairly immediate urine or blood tests. Where the employee was involved in a workplace incident or near miss, or where the employee is returning from substance abuse treatment. In terms of recognizing impairment, then, knowing that in, putting aside the larger employers who have, significantly high amount of safety-sensitive positions that require general testing, if you put those aside, what are you going to use in order to recognize impairment at work? I've just put up a few notes here that are provided from the Canadian Human Rights Commission. What this is are objective criteria. This isn't, guessing because you think somebody at work is a pothead or a stoner. This is looking at an individual in a specific situation on a certain day and objectively identifying indicators. And this is certainly important for both employers and workers. As I noted, workers are active participants in ensuring that culture of safety. Workers need to be able to say, in a safe way, both to their coworker and to supervisors, I think that there's a problem over here. To take a really basic example, I would at least hope and would expect that any worker who saw that a guard was malfunctioning on a piece of equipment would, stop work, would say to whoever needs to be informed, there's a problem over here, this needs to be fixed. I think that workers need to approach this the exact same way, impairment the exact same way. There's an issue that needs to be addressed. In some instances, the supervisor may come over and say, no, you're looking at this the wrong way. That guard's working just fine, but thanks for stopping and raising this, and everybody can get back to work. That may be the outcome where somebody suspects impairment. So again, then when we're talking about policies and the importance of policies, recognizing impairment, there is a level of knowledge and supervision, or knowledge, education that's important. At the same time, you need to recognize, and it's okay to recognize, you are not drug experts, you are not impairment experts. You don't have to meet, that standard that an expert witness would. But bring it back to sort of first principles of dealing with issues in the workplace. You're going to have your investigation, you're going to have those conversations. This is really where it needs to start. I just have two quick cases that I'm going to go over, and then I'll leave a couple of minutes for questions. The two cases are both labor arbitration cases. In this sort of line of work, we find that some of the best decisions come from the arbitration ones because you really don't see it so much in a non-unionized workplace. If somebody's impaired, you know, they can just be terminated, and it's a little bit easier than in the unionized. So, but the principles apply in a non-unionized work setting almost as much. So the town of Kindersley here, ultimately the arbitrator found that the termination was appropriate. This griever had authorization from his physician to use cannabis during the workday, provided he did not operate a Zamboni forklift or lawnmower for 20 to 30 minutes after use. It's like the most Canadian case ever. You can't use the Zamboni, right? But during a work trip, the griever was observed using cannabis while driving the town vehicle. So, and that was not authorized, not authorized at all. And the termination letter, I think this is important, indicated that the griever's employment was being terminated as he was impaired while operating or being in control of the town vehicle. Of course, he grieved, and it could not be conclusively determined that the griever was impaired. They hadn't done a drug test. There was no direct evidence that this person was impaired at the point of time, but it was still upheld because of the clear violation of using cannabis while operating a work vehicle. I thought another interesting point was that the Board of Arbitration noted specifically that it did not endorse the medical restriction on the operation of equipment for only 20 to 30 minutes after consumption. And I think this is important because arbitrators are also not medical doctors, and everybody out there is searching for the test or what's acceptable, what do we need to do, and here they were really careful to say, we are not agreeing with this 20 to 30 minute restriction. Finally, this case, it's a Tizard case out of Newfoundland. The griever was hired into a safety-sensitive position on the condition that he passed a drug test. And this is pretty regular. We see this quite a bit, conditional hires into safety-sensitive positions. The griever, who did have a prescription or an authorization for medicinal marijuana, had not disclosed this authorization. And I wonder very much whether this case would have been decided differently if he had disclosed that at the point of hire. The griever failed the test, and then the employer refused to hire him. So relying on literature and expert testimony indicating that the impairing effects of cannabis can last up to 24 hours and that there was no readily available testing to adequately measure impairment, the arbitrator determined the unmeasurable safety hazard amounted to undue hardship. And this is what I was talking about, this pendulum sort of switching back. I'm not sure that this case would have been necessarily decided the same way even 3 or 4 years ago. So the decision was judicially reviewed, essentially it was appealed, and it was upheld on judicial review. So I think that cases like this are going to be really interesting to watch, you know, equally for employers and workers. In terms of high-level key takeaways, to leave time for perhaps a question, you want to make sure that your policies are up to date, that they're clearly communicated, that you've got worker buy-in, that workers have opportunities to ask questions about it, to know the expectations that are placed on them, and to know that employers and employees have a shared obligation to prevent impairment in the workplace. I'll end there. I know we have time for questions. There's a couple microphones here, and I'm also going to be around for the next few hours if anybody wanted to come up and chat. Thank you so much for your attention.